Every Tuesday, Reddy Neumann does bring in immigration updates. We do take live questions every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time. Emily, what do you have today to discuss?
Yeah, we had an interesting announcement, I guess, or I think it was on a podcast. Former President Trump, soon to be presidential candidate Trump again, saying that he wants to staple green cards to your diploma when you graduate from a U.S. university, whether it's a PhD, master's, bachelor's, even an associate's degree. Is this a new side of Trump? Is it something he could even do if he was elected? Would he actually do it? We'll discuss all of those. And then we're going to talk about a somewhat common but tricky situation where people get married on what we call on paper. So they actually go through the process, but they're not actually living together. They're not actually holding themselves out as married because they want to do that later after they have the actual religious ceremony. And then they'll let all of their friends and family know. How does that work with the immigration process? Is that something that can be done? What if that spouse is applying for an H4 visa at the consulate, or what if you're trying to apply for the green card as a spouse in that situation? And then we're going to talk about a very common issue right now is maintaining legal status after a layoff. So we're going to be focusing on the I-539 application form, specifically to change to B2 visitor status. What are the requirements, the process, tips in order to make a strong case for that to get the approval so that you can switch back to your non-immigrant work status once you later find a job. And lastly, we'll look at those in adjustment of status. What are your options for opening an LLC? Can you use your EAD card for that? We'll cover the legal considerations, benefits, restrictions that you need to be aware of so that you can be in compliance while also pursuing your entrepreneurial dreams.
Emily, let's look into history of Trump. He was the president of the United States for a period of 4 years between 2016 and 2020. And of course, he is contemplating that he is going to be the president from 2025 to 2028. Now, when he was the president of the United States and when he previously got elected, though, he took the stance of anti-immigration. In particular, especially that is more concerning to our audiences, is the employment base. He said that it's the H-1Bs of the thieves of American economy. He said immigrants are undesirable people. He tried to eliminate the 7th-year extension of the H-1B. He tried to eliminate the H4 EAD, which was granted at the time of Obama period. He definitely stopped approving the H4 EAD's approval along with the H-1Bs. He started giving the short H-1B approvals, which we used to get for 3 years. We were getting only 1 year and sometimes even 6 months H-1Bs. He started giving H-1Bs, RFEs, where if it's a level 1, it's not suitable for the specialty occupation. And we also seen at least 20-fold denials or even higher in some of the companies of the H-1Bs. Now he comes with a bold statement that he's going to staple the green card along with the degrees and including associate degree in a podcast. Now, how reliable is Trump? And he is the presidential candidate, undeniably, the Republican presidential candidate for this election right now. So it's going to be either Biden or Trump. Those are the two choices that are there. Let's not get into the topic who is going to win, who is not going to win. That's not our topic. But of course, he has a probability of 40 to 60% of winning. So what do you take on his statement, Emily?
I'm going to use your words against you and say if it looks like a duck, it talks like a duck, and it walks like a duck, it's a duck. He did everything he could that was anti-H-1B, anti-green card, anti-immigrant for 4 years. And now all of a sudden he's going to give out green cards like they're candy. Not that he's actually doing that, but no, I don't think he's had a change of heart. I think that he's going to continue what he did before. There's already I think, what is it, the Heritage Foundation or some sort of 2025 project. I can't remember the name of it, but there's paperwork out there of what he's got planned, and it does not include giving out more green cards or for people that have a U.S. degree. So I'm very skeptical of that. I mean, as a president, he doesn't have the power to do that anyways. Only Congress can decide who gets green cards and change those requirements. I don't know if he would be able to get Congress to agree to do that. It's kind of funny. I feel like the Democrats should be jumping all over this and trying to pass a bill right now that says, hey, even Trump's on board with this. Let's do this. They're all supposedly for it. So I don't know. I'm not holding my breath for that one.
Well, I definitely, between Trump and Biden, I definitely like Biden administration much better. And the immigration, I trust Biden administration much better than Trump. The things what Trump says, it's very unreliable, but I have to welcome his statement at this point of time, Emily. I welcome President Trump's statement that he wants to do something better for the employment-based immigration. He has some positive sides. He has come out from a business angle. He said that these people are going and becoming billionaires elsewhere. He would rather want them to become billionaires here in the United States. When I looked into the press statement that was released later on by the Republican Party, they were kind of saying that we're going to vet out the system and probably will do some favors to the employment-based. We will take out those people who support Hamas organization and certain other things, of course, which most of our guys don't, or if not all of our audiences won't. And then they will do some favors. That's the way that Republican Party sounded in defending what the President Trump has said. So at least I would welcome the statement made by him. It's not, as you pointed out, it's not legally possible for the president to just grant the green cards. But of course, he can grant the employment authorization. He can grant the employment authorization to all the people whose I-140 has been approved and doesn't have any criminal record. Certain provisions he can make. He can stop counting the family members. And then look what Biden administration has done. He has given 500,000 people employment authorization just now. Recently announced that these people will be getting the employment authorizations in the executive order where the people who are not documentedly present in this country. So they can, the president, even if he cannot grant the green card, can do some favors of granting the employment authorization to certain people, can probably stop counting the family members. So there could be some things the president can do. I do welcome President Trump's statement about this. Whether or not it's trustworthy or not, we will come to know later on if and when he becomes the president. But as of now, I do welcome President Trump's statements, a positive attitude towards and understanding that what the foreign graduates are capable of, and he can probably, if he benefits it, it's going to be much better for the foreign graduates and also for United States of America.
All right. We'll see if it ends up being fake news or not.
Well, he's not a loose-tongued person as such. My opinion is sometimes a bad tongue, at least to some people, but he's not that loose-tongued person. So let's see how it turns out if and he becomes a president, Emily. Let's go to the second topic, Emily. Can I move to the next topic, Emily? Mm-hmm. Second topic is, I do see a lot of 221Gs in the consulate recently, and not a lot, I would say very less number of them. In that less number of the times, though, where the H4s get the 221Gs, that's very rare to get H4 221G. And when I ask them, hey, show me your profile on the LinkedIn or Instagram or Telegram, I don't know, whatever those social networks are, these people are not holding themselves as wife and husband. I asked them into detail. And they said, yeah, we got married on the paper. Yes. Are you living together? No, we are not living together. They're not announcing to their friends and relatives that they are married. And they are appearing in the consulate for the H4 stamping, though. That seems to be very dangerous, though. Marriage is not a secret affair. Okay, it is a public matter. You need to announce the entire society that you are married. That is an absolute necessary for the immigration, and the immigration, either it's a State Department or the USCIS, ICE, CBP, they are looking into all your social media. So don't do the paper marriage and then present yourself as a married. You need to be living together. You need to hold yourself out as a married couple when you go for a visa stamping, when you apply for the green card, when you're applying for a dependent visas. This is an absolute necessary.
Yeah, it definitely has to be a bona fide marriage. So just getting married on paper doesn't cut it. They're going to be wanting to confirm that you're living together, that you are commingling your finances, that you've gone on trips together, that your family members are aware that you're married. So it's a lot more than just going through the legal process of getting married on paper in order to actually qualify for any kind of dependent visa or for the green card, whether it's employment based as a derivative spouse or family based if you were to marry a U.S. citizen. Same rules apply. It has to be an actual legitimate marriage.
Anything else, Emily, before I go to the next topic?
Nope.
So I lose the job. I'm an H4B, and I have an I-140 approval. And can I move to B2 to look for jobs? Because I know that there is a 60-day grace period. If my I-94 is valid, there's a 60-day grace period. I can stay in this country even if I lose the job on H1B for a period of 60 days. And if I'm not getting the job in that 60 days, can I move to B2? And can I search jobs on B2, Emily?
So a year ago or so, I would say absolutely not. You cannot do that. You have an approved I-140. You have immigrant intent. You're not going to get a B2 approved. And the processing time is so long that your status is going to expire while you're waiting for it to get approved. And that's not a valid reason for a B2. You can't do those things on a B2 looking for jobs. Well, fast forward, and now we have this option that is available based on how USCIS is actually adjudicating these based on an update that's on their website that now says the fact that you have an I-140 approval does not negatively impact your ability to get that B2 approved. Their processing times are better, but on top of that, they've even come out and said if your B2 is still pending and you do find a job, when you file a change of status back to H1B, we will approve it even though your B2 is still pending. They never used to do that before. They would send an RFE asking for proof of the B2 approval, and when you didn't have it, they would approve the H1B but deny the change of status, meaning no I-94. Now you've got to exit, get the visa stamp, and come back. So all of that is eliminated based on how the Biden administration is adjudicating these cases. So that's a huge plus, a huge benefit for people who are facing this situation. We file these types of applications daily. We help people through consultations that decide to file them on their own. It is a pretty simple process, pretty straightforward, and definitely something to consider when the 60-day grace period isn't enough these days. In this job market, it's hard to get, go through the rounds and rounds of interviews and then finally get the offer, and then they take forever to process the paperwork in order to file within 60 days. It's practically impossible. So filing that B2 change of status and then a change of status back to your non-immigrant status is definitely a good option.
People need to note down that you can file the B2 application online. It's very easy to file the application. We normally tell people to consult us after you fill the online application called I-539 application with the general questions that they come up with, and it's so easy. The processing time is only 2 months right now if you file it online. If you file it manually, it takes a little bit longer time. So USCIS in its website has clearly mentioned you can move to B2 application and you can look for jobs. Absolutely, that's not a problem. And once you file the B2, we have had many situations of thousands of times people have filed a change of status even when the B2 is pending We have had the H1B approval with the I-94, and even if the B2 is approved, they got the H1B approved, has no issues at all. So we encourage people, instead of uprooting themselves out from this country and then going to your home country and coming back, it may be worth for you to stay in the country for a period of time and to see if you can get a new job within that extra 6 months. So it will be 60 days plus 6 months. So it's almost 8 months time that you have that you should try if you want to. Emily, on the AOS EAD though, I'm working for Microsoft company. I have an adjustment of status EAD. Can I open a side company on a real estate, or can I open a restaurant on the side and do business?
Yes, you can. A business that you are a passive investor in is different than being employed. So you're probably all familiar with H1B rules, L1 rules, that you're only allowed to work for the company that has sponsored you. But that doesn't mean you can't invest in a business and even work for that business when you have an EAD. The EAD allows you to work for any company, including your own company. There's no restrictions on it other than don't do anything related to marijuana or things that are illegal. But you can actually own a business using an EAD. You have to make sure that to support your green card application, you always have that valid job offer of permanent employment in a position that's either the same position you were sponsored for if you're still with the same company, or in a similar position if you've moved on under AC 21. But on the side, while you have that permanent job offer, you can use that EAD to start a company and actually work for that company. If you do that and you had an H1B or you had an L1, it will take you out of H1B status or L1 status because you're not allowed to work for any company that did not sponsor you. So you'll be in adjustment of status from that point going forward, relying on your pending I-485, use the EAD to work, use your advanced parole to travel going forward. But it can be done. What are some of the things that people need to be aware of if they decide to go that route?
Emily, as long as they maintain the main job in the similar profession, they're perfectly all right. If they want to do on the side income, they can open a company and they can do legal business. Absolutely, that's not a problem at all, especially on the adjustment of status EAD, Emily. Can we go to the questions, Emily? Unless you want to.
Yeah, I think so.
People are asking questions with regards to the passport stamping in United States. This is a routine question that is coming up every week. We will update you if there is any passport stamping in United States. There was a experiment. They did it successfully. They intend to expand it. But as of now, no announcement has come from the Department of State. No public statement has come out. When and if it comes in, we will have a private separate bulletin that will be coming on. You can subscribe to a news channel so you will get information as soon as any such information comes up for that. People are asking questions with regards to the PERM applications. What's going on right now? I just looked into it. The PERM applications they are still adjudicating the applications in the month of May of 2023. When we had the court litigation, we found out that they do in batches. The batches are within that particular 1 month, though. At this point of time, I have not seen any labor certification that we filed in June of 2023 approval. It's still in May of 2023 that we are seeing approvals, but none in June of 2023.
Yeah, and that means that we still have 0 cases that have been approved in the new flag system. We did learn that because of the new flag system and the way it interacts with the prevailing wage, when we're filling out the labor certification, we don't enter any information about the job onto the PERM form anymore because it's automatically entered through the prevailing wage. And our understanding is, based on what was shared at the AILA conference, the PERM approvals in the flag system are going to look completely different. They're not going to have any of the job details on the PERM approval. That means you're going to have to submit the perm approval and the prevailing wage determination, and hope USCIS officers have been trained at how to read them both together to determine what exactly the minimum requirements are for the job and to determine that you actually qualify for the job. So not only has DOL had no training on the new form, I'm pretty sure USCIS has had no training on this new form. So we're in for a little bit of a bumpy ride once they get into these flag cases for a couple of months until they work out all the kinks.
Apurv Shruti has this question. Can I invest in the business which sponsored my H1B? The simple answer is yes. However, there is some problem, especially if the same company is going to sponsor you at a green card later on, though. The company has to disclose that you are one of the person who own the company, especially if it crosses a certain limit. If I'm not mistaken, it's a 5% limit. If it crosses that limit, it has to be disclosed. So that is one of the conditions that may become a problem at a later date, though. Rakesh is having this question that he has been employed for a while, but in the last 3 months, he doesn't have the pay stubs with the company. Can the company still file an I-140? And can the company prove ability to pay? And he's asking me the question, how can the company prove the ability to pay? It's a very complex question. Maybe one time we have to do a video on the ability to pay, but let me explain that. Ability to pay is the company has to tell to the USCIS that they have the capacity to pay the salary. As everybody knows, there is a prevailing wage for the POM application. Let's say the prevailing wage comes out to be $100,000. And the company has to show to the USCIS when they file an I-140 after the POM is approved, that the company has the ability to pay the $100,000. There are multiple ways to prove it. If the company is already paying you $100,000 or more, then they don't need to prove anything extra to say that the company has the ability to pay. If the company is not paying $100,000 salary, then the company has to show, based on the tax returns of the company, look, we have a profit of $200,000 last year, and now we only paid $70,000 to John Doe. The $30,000 will be covered within the $200,000 profit that we have. That's one thing. And then they also can show net assets of the company. If the net assets of the company are, let's say, $100,000, they can show the net assets. They can either show the profits of the company or net assets. It's not a combination of both the things. Now, there are also, USCIS may come back and say, look, buddy, you have filed for 20 different people. Now, you show the ability to all 20 people. So in that way, it complicates a little bit in that situation. Let's say, for example, 3 of the people are not even working for the company. Then what happens is that let's assume that everybody's $100,000. So it's going to cross the $200,000 limit, but there are still multiple ways of getting the ability to pay. Especially our lawyer, Mr. Ryan Wick, who is a partner in our law firm, has done so many successful ability to pays. He has different ways. For example, if the labor certification has been filed in July 1st, okay, and if it's from July 1st onwards, it's only $50,000. And if the company has paid $100,000, he adds that $50,000 as a profit. There are a lot of different exceptions that are available, where creative ways where you can, for example, if one of the employee, the company is paying $200,000 salary, but the prevailing wage is only $100,000. He adds up into the profit of the company too. So there are multiple ways where the company can prove the ability to pay. The complex cases of the ability to cases were handled, I can say, by Ryan Wick, a partner in our law firm. He does that day in and day out. Is very good. If there is any RFP on that, we strongly recommend to consult Ryan Wick. If necessary, have him respond to the RFP.
Chaitanya has a Canadian passport, has an I-129 petition in process, and wants to know if it's going to be a problem if he travels to the U.S. as a visitor while this H-1B is in process. It definitely could be. You're taking a risk there that may not be worth it. The issue is when you're coming in as a visitor, you need to meet all of the qualifications and the requirements and criteria for a visitor, including having a residence abroad that you don't intend to abandon, having ties to your home country, including employment in your home country. And so now when you're coming to the port of entry, because you don't need a visa stamp in your passport, and you're telling the officer you're coming in to visit, and they see this I-129 is in process, they're going to think, well, you have a job here, not in your home country. You don't intend to return to your home country. Or they could think, well, he's just coming in early to start working now because the H-1B won't start until October, and he wants to get us a head start and start working without authorization because a B1, B2 does not allow work. So you're definitely at a risk there. And you'd have to decide if it's worth it, if you feel that you can convince an officer that your purpose of coming into the U.S. is properly aligned with the B1 or B2.
Shubham has this question. His H4 H4 EAD standalone is pending for a long time and is filing for the H1B extension. Can he withdraw the H4 EAD and file the H4 and EAD extension at the same time? Is the question that's coming from Subham Sharma from Facebook. You don't have to withdraw the EAD that's already filed. You can keep it as it is and file a H1B, H4 and EAD together at the time when you file the H1B. And just because you have your spouse has an other H4 EAD pending, it's not an hindrance for your wife or your spouse to get another EAD. Absolutely, you don't have to withdraw. You can file the application. Krishna is on green card. Well, congrats on that. And he has one job. Can he work on a part-time on a different job? Let me tell you one thing. My wife at one time got 8 W-2s. She was working for 8 different companies. She's in the healthcare industry. In the healthcare industry, it's very common for the people to work for multiple companies, especially if they are on call. That's very common. Now, if you want to do in the IT industry the same thing, absolutely you can. Now, he's asking another question in there. Does he need to inform the primary employer? As far as the immigration rules are concerned, you are under no obligation to inform the employer. Now, if it's up to your courtesy, whether you are any contractual basis, but as far as the immigration law is concerned, you're under no obligation to inform your employer that you're working in a part-time elsewhere.
Vicky says, I'm approaching the H-1B 6-year limit and have spent time outside the country. When can I claim those days? Is this before 6 months or for a specific time period? So it's usually in your final extension. So let's say you're hitting your 6-year limit a year from now, and that's your current approval notice is valid till that time period, a year from now, June 2025. Well, you cannot file an extension more than 6 months early. So that would mean in January 2025, you can file an extension to recapture whatever time you have left of your 6-year limit, including time spent outside the US. So it's when you're filing your very last extension to hit the 6-year limit, and then you can add whatever time you've spent outside the US on top of that.
Emily, this question is coming very frequently. Puneet is asking this question, but I want to elaborate this question. I need some debate and discussion on this question, Emily. Puneet is asking question that if he moves to the adjustment of status EAD and AP status and he lets his H1B fall out, I mean, he doesn't extend it. Assuming that his AOS gets denied, is there a way to get back to the H1B? Yes, the company can file a consular processing H1B. You can go to India and get the stamping of the H1B. That definitely provision is there. But Puneet, there is also another provision, assuming your advance parole is valid, and let's say you get an RFE. Let's say you get an RFE, and the RFE looks very bad that most probably your 485 could be denied. Assuming you have an advance parole, you can still file a H1B, go to India and get the stamping while the adjustment of status is pending. So you have these two provisions where you can get back to H1B. Emily, any other provisions to get back to H1B if there is a problem with the adjustment of status?
No, that would be all I can think of.
You think so? It's complicated, Emily, to get back to H1B?
No, I mean, part of it would depend on the reason for the 485 denial. Let's say it's denied because you committed fraud or misrepresentation. Well, that's also going to be a problem for you to get the visa stamp for a new H1B. But if it's something, related to the company or the job offer or something like that.
Or let's say, for example, the guy forgot to respond to the RFE and the medical.
Yeah. Or USCIS didn't get the response, even though it was responded to. It's not that big of a problem. It just takes time because the company is going to have to file the H-1B, get the LCA, file the H-1B, get the approval, then you exit, get the stamp, and come back in. So it's definitely not fatal in that situation.
And not that complicated either. Not that complicated. We don't see those many situations where we have to do that. But yeah, once in a very, very rare time, we do those kind of situations.
Sapta says it's been more than 7 months since he filed the I-131 for advanced parole. 485 has been current for more than 3 months. He has a travel plan and is stuck. His father's having surgery. And he's not able to be there with him. These I-131 processing times are still terrible. Every day in the mail, we are getting approvals for cases that were filed in June and July 2023. Finally getting approved. Some are happening a little bit faster, but yeah, definitely 7 months is not pending long enough. It's still considered to be reasonable by USCIS. So your option is to request an expedite, assuming you don't have an H-1B or non-immigrant status, H or L. Request an expedite regarding your father's surgery. Hope that works. If it doesn't, a lawsuit, it might be time for a lawsuit. And you can reach out to Stephen Brown in our office regarding that. He can help with determining whether the time is right for you to do a lawsuit for the I-131 delay, as well as possibly the 485 delay, since the date has been current and they still have not adjudicated it.
Suresh Goel has this question. I won't say I would laugh at this question that he asked. He got his green cards. The whole family got the green card. Congrats. That's very nice to hear. Do we need to worry about the I-94 expiration dates? Absolutely not. Here you go. Take your H-1B and throw it out. You don't need it. You don't need I-94. Absolutely, you don't need it. That's a very funny question, though. Now, anyway, I have some questions coming on the Trump. Does he make it 7% quota disappear? That question. Well, he didn't answer that in there. That has to be something done by the Congress. In the United States, we call the parliament as Congress. That need to be done by the Congress. It cannot be done by the Trump administration by itself, though. There are also people asking questions, hey, why not? Why only for graduates? Why don't people who are waiting for a priority date to be current? Well, in general, if I have to take what he said is, most probably it's in favor of the employment-based immigration. That's how I take it. Now, Emily does not trust the statement. Emily does not trust Trump anyway, but, I do welcome what he said. But if he's going to give the green card, if assuming that he's going to give all the green card to all those people, then it definitely makes easy for everybody else, guys. So definitely, it's a positive sign. It's not a very concrete information given in detail, in depth, in writing. It's just a podcast that happened. I don't think so. It was planned very well. It was not discussed very thoroughly. So we can't dig into all the details at this point of time, why he did it. And we will see as the things develop, though.
Meher says, my wife is currently on H-1B. If we apply for her H4 EAD with the change of status to H4, can she continue working on the H-1B until she gets her H4 EAD? Most likely, yes, assuming that the H4 doesn't get approved by itself. Then if the H4 and H4 EAD get approved together, yes, she can consider herself to be still on H-1B while they're pending, even after they're filed. And also assuming her H-1B does not expire while she's waiting for the H4 and the H4 EAD to be approved. But most likely, yes, she can continue H-1B status even while the H4 and H4 EAD are pending.
Can an employer on STEM OPT place an individual, STEM OPT, place an individual at an end client location and provide training remotely? This question comes from NP. The answer is clearly yes. With regards to only one employee from this company, though, that is a little bit doubtful. If they don't have other employees, they're operating everything just for you. I normally recommend to go to some kind of established company rather than just a one employee company. But in general, companies can place individuals at third-party location and give the training while remotely. That's absolutely legal.
SS says, I'm in my second H-1B phase. It's valid till 9/26, assuming that's September 2026, along with dependents on H-4 have an approved I-140. We never went for H-1B stamping. Do I have to be concerned? No, that just tells me you never traveled. If you don't travel, you don't need a stamp ever. You can go straight from entering on whatever visa you entered on, change of status to H1, change of status to H4 for your dependents, file the labor certification, I-140, 485, receive the green card without ever getting another stamp again. The only time you have to get the stamp is if you exit and want to come back in.
Abhimanyu has this question. He has his I-140 approved. It's been approved for more than 6 months. Now he is intending to move to a new employer. How soon the new employer need to file an I-140? Not in the next 10 years. Assuming your priority date is somewhere in 2019 or 2020, not in the next 20 years. You can use company A's I-140 approval to move to company B, from company B to company C. You can still use company A from company C to company D. You can still use company A from company D to company E. You can still use company A, and so on and so forth. For the next 20 years, it's safe.
Sloshali says, could you please explain how USCIS prioritizes applications after filing the 485? It's been 4 months since I filed and I'm still waiting. How long is the usual wait? Well, the usual wait can be up to 2 years, 3 years. It could be less than that. It could be 3 months, 6 months. It's all over the place. So short answer is they don't seem to have any way to prioritize one over the other. They're not doing first in, first out. They're not necessarily doing it by priority date. The wait does depend on when you filed. Was your final action date current? Is your final action date current now? If it's not, you're going to have to keep waiting until the final action date is current. Was your I-485 filed with a I-130 or I-140 that's still pending? Well, in that case, they can't touch the 485 until your I-130 or I-140 gets approved. Did you submit the medicals? If not, you're going to get an RFE. That's going to make it take longer. So there are a lot of moving parts to how exactly they prioritize them, but it literally could be 6 months. It could be 3 years. And then if your date goes backwards while you're waiting, which happened to a lot of people who filed in 2020, it's, taking 8 years for their date to become current again. We had people still pending from 2010, 2012 in 2020, and they finally got the green cards 10 years later. Mender says, if someone on H-1B who has their third extension in place, their I-140 is approved, so they're beyond the 6-year limit, if they lose their job and have to move to H4, can they move back to H-1B, and can it be cap exempt? Yes and yes. Once you've been counted and you have an approved I-140, you don't have to go through the lottery again. Even if you exit, even if you change status to something else, and you can come back to H-1B anytime in the future, as long as your priority date has not become current yet. So you can go back to your home country, you can stay there for 20 years, and then as long as your I-140 priority date is not current, even though it's with an old employer from years and years ago, any company can now file an H-1B for you. Doesn't have to go through the lottery. Get it approved for consular processing, you go for visa stamping, you come back, now you're back in H-1B, and you can keep extending every 3 years until your priority date becomes current and you file the 485 based on a new labor and new I-140 at that time.
If I switch a job after 6 months of the questions are coming on I-140 approval. If I switch a job after I-140 has been approved for more than 6 months, and when I move to the second job, does the second job, the company B's job, has to be in a similar profile? Absolutely not required. Let's say you have an I-140 approval as a software professional, and later on you got a law degree, assuming that, and then you move on to company B, and company B, let's say Reddy Neumann P.C. is company B, and we welcome you as a lawyer in our office, and then you joined us and you started working for us. Can we use that I-140, company A's I-140 approved under software professional, to file a H-1B extension as a lawyer in our office? The answer is straightly yes, we can. Absolutely, it doesn't have to be the same profile. Question, go ahead.
Jared just saying, I'm doing a part-time PhD while I'm on H-1B, but I lost my job. Now I've got an I-20 to switch to a full-time PhD on F1. If I file the change of status from F1 to H1 during the 60-day grace period and get that approved, can I later come back on H-1B? Yes, absolutely. If you have not used up your 6 years on H-1B, you can convert back to H-1B anytime and finish up those 6 years. You don't have to go through the lottery to do that. And if you have used up your 6 years, but you have an approved I-140, you can still come back to H-1B anytime, as long as your I-140 priority date is not current, and it can be with any company.
Jashwant has this question. When does the 180-day rule for the perpetual I-140 approval start? Is it when it's approved or when it's been received? It's on approval and not receipt notice. We strongly recommend people, if this is your first I-140 approval, go for the premium processing. That's always better for you to do it.
Sunil says, what is a function manager in the EB1 category? So this is EB1C, similar to L1A. This is for people who worked for a foreign company for at least 1 year in a managerial or executive capacity and are now being offered a permanent position in the U.S. as a manager or executive. There are 2 types of manager options. There's a people manager and a function manager. People manager means you've got direct reports under you. They report to you, you're doing their performance reviews, you're spending your time managing those people. At least 51% of your time is spent managing those people. If you are a function manager, that means you are in charge of a function of the company that is essential for the company's operations, like accounting or marketing. And you may not have anyone reporting to you. You're a department of one, but you're in charge of that particular function, and you have to show that you operate at a high level of authority, discretionary decision making with regard to that particular function. But you do have to show that you are managing the function, not doing the function. That means you have to show that there are other people that are actually carrying out the duties of the function, even if they may not be reporting directly to you on an organizational chart.
Abhimanyu is asking this question. Can a STEM OPT person apply for an I-140 without going through the H-1B process? The answer is yes, they can. The next question people should ask, and sometimes people ignore to ask, is, will the I-140 automatically allows you to work if the priority date is not current? For most of the Indian nationals, it's not. The I-140 will not allow you to work in United States. The I-140 will not allow you to skip the H-1B lottery. The I-140 may have some negative impacts if you have any travel plans on F1 visa. It has a lot of positive things. I just told you some of the negative things, especially establishing a priority date earlier. That's normally better. Always getting the I-140 is good, because later on your company may not be able to file the I-140 for different reasons. But yeah, there are some disadvantages. You can't just work based on the I-140 approval. And you can't just get the H-1B just because you got the I-140. You still have to go through the lottery system. People forget about that. They think that by getting an I-140, they get an employment authorization automatically.
Amlan Jyoti says, can my 19-year-old daughter who's studying in college in her second year now file for F1? If yes, and if our priority date becomes current in the next 2 years, meaning before she turns 21, can she still be eligible to file the 485 with us as a dependent? Does she need to go out of the country and come back with F1 stamping? Or is, do we want her to be able to do internships? So I'm assuming your 19-year-old daughter is currently on H4 or L2, some sort of dependent visa category. So assuming that the main applicant H1B holder, L1 holder is maintaining status, that means your daughter is maintaining her non-immigrant status. And yes, she can file a change of status to F1 while she stays in the US. You could do it premium processing, or you can do it regular processing. It's much easier now than it was during the Trump years, because then we had to do all these weird bridge applications and gaps were coming because the processing times were so long, but it's relatively straightforward to do it now. And then once she is on F1, the school can authorize her for CPT to do a summer internship or something like that, so she can lawfully work, because on the dependent visa, she cannot. Then let's say 2 years from now, your priority date becomes current, you're on H1B and she's on F1. Can she still file the 485 with you? Absolutely. They do not have to be your dependent on a non-immigrant visa to be your dependent on your green card. So as long as she has not turned 21 yet, whether it's her actual age or her CESPA age, the Child Status Protection Act age, as long as that's under 21, she can still file the 485 with you, even if she's on an F1.
Achyut has this question. I'm applying for national interest waiver. This can be filed, as people may not be aware, this can be filed by individuals or companies, and he's filing a national interest waiver in premium processing. When can he file the H4 EAD for his wife? Assuming, Achyut, that you do not have an I-140 approval before, you have to wait for the I-140 approval. Only once the I-140 is approved, you can file for H4 EAD. Question from Vijaya Reddy. She's asking this question, that if I have an I-140 approval with company A, I move to company B. When the priority date becomes current, can I file the 485 application without going back to company A? The answer would be no, but there are some exceptions. If the company A wants to file a green card for you, even though you're not working for that company, they can. But eventually, everything will be with the company A. They will control whether you can file the 485 based on their I-140. Whether or not you're working for that company may not be relevant, but still, the company A, only company A, can allow you to file the 485 based on their I-140 approval.
Binod from Facebook says, can an employee on EAD continue their job while the EAD extension is in process along with the primary H-1B holder? I'm going to say no, because since you mentioned the primary H-1B holder, I'm assuming this is an H4 EAD. H4 EADs can get the automatic extension, but there's a trick to it. Just filing the EAD extension by itself does not give you the automatic extension. You need to have either file it with the H-1B, with your H4 and your EAD all together in premium processing and get them all approved together before your current EAD expires, or once your H-1B spouse gets the H-1B approved, you may be able to travel on H-4, show the H-1B approval notice to get back into the U.S. and extend your H-4 I-94 that way, because you need an extended I-94 with the renewed pending EAD in order to actually get the auto extension. We have an entire video on just that topic. If you look for H4 EAD renewal, automatic visa revalidation, or any of those, search for it on our YouTube channel. We have a lot of discussion of how exactly to go about that.
VVM is asking the question, if he loses the job, he's a green card holder, is he eligible for the unemployment benefits, or is it going to cause any problem for his green card or citizenship if he applies for the unemployment benefit? As the green card holder, you are eligible for unemployment benefits. If you are unemployed, you can apply the unemployment, you can get the benefits. It's going to have zero impact on your green card. It's going to have zero impact on your citizenship if you claim unemployment when you are unemployed.
Sam says, my I-140 was recently approved. What are the fastest options for my spouse to get the H4 EAD? Assuming that your H-1B is not expiring in the near future, the fastest option is to file an H-1B amendment plus extension, because you can only file an extension 6 months before it expires. So if it's not expiring in the next 6 months, you have to file it as an amendment, file it in premium processing, file the H-4 extension and the H-4 EAD along with it. They should all three be approved in premium processing. That's the fastest way to do it. Every other way is going to be waiting for the I-765 processing time.
Amit Kilker has this question. He has an I-140 approved and he's an H-1B. His wife is an F1 OPT and did not get selected in the lottery. Can we file the H4 EAD for her while she is still on F1 OPT? Absolutely, she can. She can file the H4 plus EAD. When you file the H4 plus EAD, you should file it together as one application. And once you file the application, she can continue working, assuming her OPT is still valid. And once the H4 plus EAD is going to approve, she can move on to the H4 EAD. You can contact us at info@rnlawgroup.com. We'll be happy to help you out for filing the H4 plus EAD.
Let's see. Babu says, I just got news that my H1 change of status I-129 petition has been approved. I want to travel to India. When should I start filing the DS-160, and how difficult is it to get a visa appointment in India? So I'm assuming this is for a cap case, meaning it doesn't take effect until October 1st. The earliest you can apply for a visa that takes effect in October is 90 days beforehand. So you should be able to do that July 1st or June 1st, if I'm doing my math correctly. So you should be able to fill out that DS-160 now. Visa appointments come and go. Just depends on when you happen to be online, whether there are slots available. So definitely start that process as early as possible so that you can line up your interview appointment while you're needing to travel.
Question is coming with regards to if I lose the job, if I apply for the H4, do I need to get the H4 approval within 60 days? Or should I just file the application within 60 days? The answer is you should, Sravanti, you should file the H4 within 60 days, assuming your I-94 is still valid for the 60 days. You don't have to get the approval within 60 days. You just have to file it within 60 days.
Kishore says, can you please highlight on concurrent H-1B filing for a second project with another employer? So concurrent filing is when you are going to continue working for your main H-1B employer, and at the same time, you're going to work for a second employer. The main employer doesn't need to do anything. The second company needs to file an H-1B petition that meets all the regular requirements of H-1B. So it needs to be for a specialty occupation. They have to offer the wage that's in line with the prevailing wage. They have to get an LCA. When they're filing the I-129, they check a box that says concurrent instead of change of employer or extension of stay with the same employer. And then once it's filed, you can start working for that second employer at the same time while you're still working for the first employer. They can specify that you will work part-time and then list the number of hours that you'll work every week, or they can even make it full-time. You can have 2 full-time jobs as long as you have concurrent H-1B that specifies that you're going to work this other job full-time. If you lose the first job, your main job, then the concurrent job, you're no longer maintaining status. There's not a lot of guidance here, but the safe thing to do would be to file a transfer to the concurrent job at that point. Be aware that USCIS, when you get to the green card stage, gets very confused and thinks it's shocking that people work more than one job. So they get confused when you show up with more than one W-2 for the same year. So you just need to be prepared to educate the officer in that situation. But other than that, it is relatively straightforward and not a big issue to deal with.
Rupak Seal has this question. He is on GCEAD. His start date is November 2014. How can he bring his 3-year-old daughter born in India? He doesn't have an H-1B and he has a GCEAD. He is an advanced parole. Obviously, since she's in India, she's not part of the adjustment of status. You can't bring her an advanced parole. Since you already have an advanced parole, though, you can file a H-1B in the consular processing, assuming that you were an H-1B at one point of time, and then you can go to India and bring your daughter on H4. And you have to maintain the H1 and H4 until the priority date becomes current. That's the only thing that you have to do right now is file a H-1B, go to the consular processing.
Dayalan says, for EB1C, can my U.S. role be a people manager when my overseas role was a functional manager? Yes, absolutely. They do not have to be the same role at all. You can go from executive to manager, manager to executive, manager to manager, functional to people, people to functional. All of the above works. They do not have to be the same.
Question. Can my Ishwar, if I lose the job on GCEAD, advanced parole, does he have a 60 days? Does the new employer need to file the H-1B? There is no 60 days for the adjustment of status. Now, there are 2 things, Ishwar, that you need to be working on. One, H-1B, you already know there is a 60-day rule. I don't have to explain you about that. But when it comes to the GC, green card, you don't have 60 days. There are different different alternative options available for you where you can have a self-employment on EAD. You can work for any different company in a similar field on EAD. You can get a job offer. If you lose the job, if you don't have a similar job immediately, I strongly recommend you contact an experienced immigration lawyer so that you can protect your adjustment of status. Protecting H-1B is different. Protecting adjustment of status is different. And sometimes I tell people to give up the H-1B to protect the adjustment of status. Because for me, adjustment of status is more important than H-1B. Because if you want to be self-employed, it's probably very unlikely to get H-1B, but it's easy to be self-employed on a GCEAD.
All right, well, we are out of time for this week. Thanks everyone for joining us. Remember that you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com. And you can sign up for our newsletter as well there so that you'll get all the latest updates, all of our articles. We're publishing articles every week to keep you informed on what's going on with employment-based immigration. So thanks for joining.
Thank you very much for tuning.